Okay. Welcome, everyone. I'm Nancy Russo from the Creatives Roundtable. I'm happy to welcome you to the client agreement that works for you, featuring Michele Berdinis. The Creatives Roundtable is a small group coaching and Slack community. We meet once a month on Zoom for accountability, support, and to learn from one another to help level up our careers as creatives. Members get free perks such as these events. Our Slack-only membership includes 50% off for these events. Both group and Slack members are also participating for free in our weekly co-working sessions, very active conversation channels on Slack, and our happy hour. We also have a LinkedIn pod, which I always forget about. Coming up in May, we have Melinda Livesey back to talk about Uncertified, a new philosophy for the creative overthinker. Then in June, we have 3 health-related events. I don't know why I decided June would be a health month. Before we have, a summer of craziness. We'll be adding you all to our email list if you're not already there. You can unsubscribe if you're not interested. Please raise your digital hand on the bottom of your screen if you want to talk. Michele said you can interrupt her at any time to do that. And now I'm going to introduce Michele. I don't really know how I first met Michele. It was either Fly Female Founders or in Creative Co. or NAVA. She and I seem to swim in the same pools in New York. Michele's company is Beeline Legal. She provides trademark registration and other legal services that help her clients do business in this messy world. I thought she only did the trademark registration, so I approached her about who would be good to talk about agreements and contracts, and she said me. So here we go. Beeline's friendly, engaging approach helps clients understand what they need, what they'll get, and what's next without all the legal speak and unexpected stuff. So I will ask you all to give a warm welcome to Michele as people keep popping in here. Go ahead, Michele, you can take it away.
Yeah, so in my current incarnation, I do mostly trademark work, but before that, I spent 20 years representing startups. So I have drafted just about every kind of agreement you can imagine and done mergers and acquisitions and all that stuff. So, and this actually, the reason I jumped on this one is because I'm really, really passionate about client agreements. I think for the most part, they stink. And so with that, I'm going to just start this slideshow here. Okay. So client agreement that actually works for you. Let's talk about it. So this was kind of in the ad, but let me just talk about the thing that I hate about most of them. When you are making a proposal to a new client, you present yourself, right? Your business, yourself. You present your creativity. You do all this amazing stuff. They get all excited and enthusiastic about working with you. And then you send them this disastrously awful agreement that sounds like some lawyer wrote it. And all of that happiness and branding and everything else that you've done is just goes out the window. And I say that it's like a dad walking into a slumber party. So it's a big buzzkill. So when I draft these types of agreements for people, I think what people should be doing, first of all, they should be in, we're going to go through each of these in great detail. They should be in plain English, right? A normal person who's not a lawyer should be able to read it and understand what it says. It should be on brand. It should, if you've been speaking in your company's voice all along, it should continue to speak in your company's voice. It should work for you to prevent project creep. It should help you upsell additional services to that same client. It has to obviously cover the important legal bits. And then it has to provide for all of the contingencies that nobody's thinking about. That's what makes a good agreement, especially a good client agreement. So let's get started and talk about, first of all, plain English. So as soon as somebody says the word whereas, or hereinafter, or hereto, your brain shuts down, you stop reading, and you just assume that whatever comes next, you're not going to understand it. So why do lawyers use those words? I don't know. because they're uncreative and they think that you have to, or they're trying to impress people. So what I have under yes here is the opening paragraph of an agreement that I created. I've changed the names and things like that for a party planning service in LA. They do like those really gigantic, insane, crazy, over the top parties. And you're going to see bits and pieces of their agreement as we go through this, because it's just a good example, right? So it says it in English, right? We promise to do our part and you promise to do your part, right? This is what it doesn't, you can actually read it, you can understand it as a person. And then I always like to say, we have written this agreement in plain English because we really want our clients to read and understand it, right? The whole point of a written agreement, right? When I ask people, why do you have a written agreement? You say, well, in case I need to sue somebody, I'll be able to sue them. And that's not the point. The point is so that nobody ever has to sue anybody. And the best way to prevent people from suing each other is if they each understand their obligations. And they're going to understand their obligations if they actually read the agreement that you present to them. And if you present them an agreement that starts off with whereas, they're not going to read it. They're just going to either send it to their lawyer and then you're going to have that, or they're going to sign it without ever having read it. And that's not what we want to have happen. Okay, so plain English, that's the first thing. The second thing is it needs to be on brand, right? It should be using your font, not like Times New Roman or something garbagey like that. Whatever font you use in your marketing materials, assuming it's not, Wingdings or something. I mean, that's what we should be using. Instead of calling it an independent contractor agreement or a client agreement or something boring like that, call it what it is, right? A soiree agreement, an achievement agreement, whatever it is, like whatever, use this as an opportunity to brand. You want your client to see the agreement and get excited all over again about the project you're about to do together, right? So whatever vision you just sold them on, let's use that as a title of the agreement so that they'll feel like this is just a continuation of the process rather than, some weird side trip that we're taking. The days of writing he/she/it, like, can we just stop that garbage, right? We can use gender neutral pronouns. We can use we and you. We can use things like that that are easier to read, just feel better for everybody and work just fine. We don't have to say he, she, it. We don't have to do that. Okay, so on brand, that's key. Okay, so let's talk about project creep. Right, so that's when you sign an agreement with a client to do a project, and this is the scope of that project, and you've laid that out really, really carefully, and then you get started on the project, and the client thought that something was included that isn't included, or they get to the certain point and they realize, oh gosh, now that you're saying that, oh yeah, I actually really did want that. Or it never occurred to me that I needed that. Can we just add that into the agreement? And you're really busy working and you don't want to have to deal with that stuff. So what you want to do is describe everybody's obligations in a way that make it really clear who's doing what for each part of the project, right? So in this case, like, for example, for the invitations, my client's obligations were to create the artwork and the wording, prepare a template, make revisions based on feedback, and deliver the final invitation. And their obligations were to do that review in a timely way, compile the guest list, right? And actually send the invitations in a timely way, right? And that way, if the client if it's written like this, the client can actually see that. And then if they say, oh, actually, I was thinking you were going to do that. Okay, fine. Then let's revise the agreement and I'll do that. And that's going to change the price because that's how it should work, right? But that's when you want to find out about it. Before the agreement is signed, you want to have that conversation, right? So again, if you lay out, these are our obligations in connection with that part of the project, and this particular layout may not work for you, but this is what you want to say. You want to say, this is what you have to do, and this is what I have to do, so that everybody understands what part of the project they've picked up, right? So for example, if there's, if they're going to need photography, right? You're doing a large marketing project for them, and you're going to need photographs in order to do that, but you're not the photographer, right? Then you should put that somewhere, that it's their obligation to supply the photographs, which means they have to find a photographer, they have to hire the photographer, they have to put you in touch with the photographer, right? And you have to work together, and the photographer needs to know what the deadline is, right? So that everything runs smoothly and you don't get into an argument in the first place. All righty. The other thing you want to do is use the agreement as an opportunity to upsell services, right? So you don't want to miss out on opportunities to do more work, and you don't want to do that work for free just because it's, you don't want to take a half an hour that it's going to take to revise the agreement and do all that other stuff. So I always include an exhibit with a client agreement that makes it really easy to upsell, right? So if they decide, a month before the party that they want another photo op background, it's really easy, right? It says, this is how much lead time you have to give us if you want to add that, and this is how much it's going to cost. And in order to do this, you just have to send me an email that says, I want to add this in, and we add it to the price. So then it's automatically covered by the agreement. It doesn't take anybody any time. And in particular, like in this particular case, one of the big things that happens is they would agree that we're going to do this party and there's going to be 150 guests. And then all of a sudden, oh, we really want to invite 5 more people. Okay, great. This is how much more it's going to cost for each additional guest, right? And this is how long before we have the event that you have to let us know, right? Because that guest list is going to grow. So don't just take on that work for free. Make sure that is added into the price, and make it really easy for them to add those people, right? So you can use this to upsell additional services. So for example, if you're doing a project for somebody and they said, and again, like it requires photography, it requires a photographer. And then they said, oh, we never got, it looks like we're really not going to have time to handle that. Can you just take that on? Then you say, sure, look, I will be in charge of the photography. Not that I'm going to do it, you'll subcontract it out, but I'll be in charge of that. But this is how much more you have to pay me. So you anticipate the different services that these people might actually need. One of the things that kept coming up with the party company is the people throwing the party said, oh, that's okay, we'll do the swag bags. We can handle that. That's not that hard. We'll do that. And then you get to like 10 days before the party and they haven't even thought about it. Okay, fine, add that in. We'll do the swag bags, but this is how much it's going to cost you. And this is the drop dead date. After that, like they're just not going to be swag bags, right? So you just put all that stuff in there, make it really easy for them to add additional services, and don't do them for free. Is this making sense?
Yeah,
Okay.
but I have a question.
Yes, please.
And if anyone else does, please raise your digital hand. Regular hand, I'd have to slide through. So in this layout, which is, certainly is easy to understand for anyone, where do you put in like a pricing column? Like if they were to say, we're going to want, I'm designing a brochure and they're going to want an insert for the brochure? Where would I say additional pages would cost blah, blah, blah?
Right, yeah, so I don't think we can see that last column because we have the people, like our images, but
No,
that
I have
last
the images going across the top and I'm just
Oh, okay.
seeing can do date and then a blank that says, to the right of 30
Oh.
days before. And
Right, yeah, so you can just add that in, right? So like in
Okay.
this case, for additional guests, we actually put in that number,
okay,
right? So you can put it there, like where it's more please, like if it's,
Yeah.
so if it's going to be something where they want additional pages, then you would, these are just examples in this particular case, but you can, this particular part of the agreement can include whatever you want it to include, and the price should be set up ahead of time. Exactly.
Okay. Does anyone else have any questions before we move on?
Okay. All righty. So that gives you an opportunity to upsell. Now the legal bits. Obviously, we need some legal bits in here. I have found that like agreements like this tend to get really long. 6 pages, 7 pages. I've seen like 20-page agreements for stuff like this. And a lot of that is because, and this goes with lay people as well as lawyers. They just throw everything in. And as a client of mine used to say, everything in the chicken sink. I don't know why he said that. It was a very weird expression. But, okay, well, let's throw that in. Let's throw that in. There's not everything is, there's clearly legal bits that we need and different types of agreements. But frankly, I don't think any of these agreements should be more than 2 or 3 pages long, plus another page for an exhibit or something like that. And there's parts of the legal aspects of it that you're going to have to use words like indemnification, or intellectual property rights that aren't, everyday English. You're going to have to put in some of that, but that doesn't mean you have to completely revert to speaking in legalese. You can still say things in a way that include those words, but also make it clear what's being said. So frankly, I just don't see any point to an agreement. I've done $50 million mergers with a 37-page agreement. Right. You really don't need, 8 pages of legal garbage in an agreement like that. Okay. The most useful part of having another really useful part of having a written agreement is that by writing things down on a piece of paper, you suddenly notice that things might not go the way that you thought, right? So-and-so has to deliver this. So-and-so has to create that. So-and-so has to do this. And then you think to yourself, well, what happens if they don't? What happens if they don't pay? What happens if you don't deliver? What happens if they're not answering any emails? What happens if you provide them with the draft and they just never get back to you with comments, right? That's really one of the main things that you can put into an agreement are dealing with those contingencies. And by writing it down, you think a little harder when you're writing something down rather than just saying it out loud. And so you can actually do that. But some of the main ones are, you need a way to get out of the relationship if it goes south, right? If you start working with somebody and it's just not working out, it's just not a good fit. You can't even figure out what they're talking about. They aren't working with you in the way that you'd hoped. You need a way to get out of that agreement if everything goes bad. You need permission to stop work if they're not making payments on time, and have that extend the due date for everything in the event that you have to stop work because they aren't making periodic payments that they're supposed to be making to you. You need to preset the fee if they want to cancel for no reason, right? Saying that they can't cancel without cause isn't really that great because they're gonna, right? So what you want to do is you want to set what that's going to cost, right? Because if you say you can't cancel unless you have a reason, unless I've breached the agreement, you can't cancel, then here's what's going to happen. They're going to cancel. And then let's say you actually sue them under that contract. You have to prove damages, right? And that may not be the contract price. They're going to argue, yeah, but because I let you out, because I got out of this agreement, then you had the opportunity to pick up that other client that you couldn't have picked up, and you made this much money from them, so you don't have any damages. So sue away, right? But if you put it in there, you know, that it's going to be really hard to figure out what the damages are if you cancel for no reason, and you put that in as a preset fee, now we know what the damages are because we set them ahead of time and everybody agreed that that was reasonable. So, and now you've got, instead of a toothpick to poke them with if they just walk away, now you have a baseball bat, right? And are you going to get every penny of that? Maybe not, but now we've just started the negotiation at $5,000 instead of at $0. Right. So when you're talking to them about what it's going to cost to get out of this contract, you don't want to start at $0. You want to start at a higher number. Yeah. Go ahead. Somebody's got their hand raised.
That's me.
Okay.
So, when you say cancel for no reason, meaning no project related reason?
Yeah.
Like they just changed their mind. We're going to go a different route. We suddenly realized we don't have the budget for this, so we're canceling it. Okay.
Yep, exactly. Yeah. So not terminating it for cause, not because you screwed up or something, but yeah, they just want to cancel it because of the reasons you stated. Exactly. Okay. Right.
So so my contract says, you know, if you cancel after the concepts, you owe me this much money. If you cancel after it's been agreed, the design's been chosen, you owe me this much money.
Yep.
That's what you're saying, something like that here.
Yeah. But remember, like, you know, you kind of want, it's not even so much that it's the prospective money that you could have made. Like, let's say the whole contract is $50,000 and there's 5 steps, $10,000 per step, and they cancel after the second step. So you don't want just that $20,000 because now you have to go out and find other work, right? So you want to get some portion of that other $30,000. It's not going to be $30,000, but it's going, you know, it should be something to, you know, for all the trouble you went through to get into contract with them and do everything else. And now you're going to have to, you know, start prospecting for somebody else, right? So you want more than just getting paid for the step that you're up to. You want something beyond that, right? And so, and again, let them cancel, let them just walk away if they want, but that's the amount of money they're going to have to pay you. And you know, people say to me, well, how much should that be? And I tell them, well, sit down and think about it. I mean, at what point are you indifferent, right? You can do this much work and get another $30,000, or you can do nothing and get this amount of money. At what point do you reach the point where you're saying, yeah, either one of those sounds okay to me? And that's kind of how you set it. Okay, so that's contingencies. You want to make sure to take care of those. And those are all the issues. Wow, I went through that awfully fast. I was expecting a lot more questions along the way. I feel like you haven't gotten your money's worth. Let me just take that away. You guys must have questions. Please help me out here. Ask them. Go ahead.
Chris, you have another question?
Yeah, I have another question.
Yeah.
This was kind of going back to the part about preventing project creep and I loved having that table there. This is task or the deliverable. This is what I do. This is what you do, blah, blah, blah. So is there a way so usually I will have a meeting with the prospective client. We'll talk about the scope and I try to get as much information out of them up front as possible, including talking about money and tasks. And then I'll go and prepare a proposal that reflects all that, maybe anything else that I think about. And so then if I prepare a table like that, I would want to send that to them before I send the whole proposal and say, okay, here is a summary of the task, the deliverables, who's doing what. I'd like you to look at this, while I continue working on the proposal.
Yep.
Do you see
Absolutely.
that as
Yeah.
being okay? All right.
Yeah. And I think a lot of these tables and stuff that we're talking about, the table for, upselling, that's going
Yeah.
to just be something you invent based on the different types of projects. And, you could probably, if you have like 3 different things you do on a fairly regular basis, you can create that upscale, templates of that you can just plug and play. But for the other ones, I mean, this is what we do, this is what you do. That can just be cut and paste right out of your proposal.
Yeah.
Yeah.
Right. Okay. Yeah. Because I'd hate to do that and then send it to them. And then they're like you said, seeing something like that is going to make them start thinking.
Right.
So I'd rather have them do that thinking and we talk again and get it in there before, I send the full proposal.
Right.
So, okay.
Exactly. And that's the whole point, right? Because you don't know what they don't understand.
Yes.
Right?
As much as you talk with them ahead of time, it's always, there's going to be more.
Yeah.
So.
Yeah. And I've been on the other side of that where, where I work with somebody and I'm not really familiar, they're doing something for me in an industry that I'm just not familiar with how people like that work. Like when I had my website built, which was, a gigantic project. It was 1,000 man hours of work. I didn't really know how a project like that worked. And so when they were saying, this is what we're going to do, this is what you're going to do, it's like, that was really helpful to me as a customer, as a client, because then I started to really understand what the process was all about. And the lead time thing is also really, really helpful to your clients. I remember the people who did all my marketing stuff, I called them once and I said, so I'm going to do a trade show, right? So I'm going to need like the tablecloth thingy and, the signage and swag and handouts and stuff. And they said, oh, that's really great. That's really great. When is it? And I said, it's in 5 weeks. And they were like, are you insane? It was like, I mean, I had no idea like what that took, right? I don't do that work. So it's really, really helpful to like, to say, these are the other things I can do for you. And here's how long it takes me to do them. Right. So that, if I had something like that from them, I would have realized, oh, if I need stuff for a conference, okay, this is how much lead time I need. So yeah, that kind of stuff it's really helpful. I mean, speaking as a client of somebody who does what most of you do, it's really helpful to let them into your brain and see what your process is.
So you're saying it would be good to send them that upsell service table too, and say, these are some things that came to mind that down the road you may decide you may want me to do. So I'm going to include them should so it's, and then do you have anything else in mind?
And they might at that point just say, oh, wow, gosh, I can get that too. Oh, well, let's just throw that in, right? I mean, really, that's like, I want your client agreement should be a sales tool, not a killjoy.
Yeah. Okay, great.
Julie?
I took a minute to unmute. First of all, thank you for including me in this. I'm just like on a mailing list somehow because I connected with Nancy probably 12 years ago. And it's a great mailing list. And this particular topic right now is for me. But my question is kind of really granular. And it's about like final deliverables versus final payment and what the sequence of that is. I do graphic design. I'm really mostly talking about either sending stuff to the printer or turning on your website. And I'm in a position right now where it's very possible that somebody's going to walk away with a book that I designed for them, and I might not get paid anything. My fault, long story, but I want it to be done. But going forward I've always said, here's what I'll deliver for you. Printer files will be uploaded to your printer, and the intellectual property is mine. You own the PDFs once you've paid me.
Right.
That's simple. But that also is all before I send them the invoice. And I feel like they should, all of it, just because of what I'm going through right now, I feel like maybe I should be saying, you need to pay me 95% before I send your printer his printer files.
Yes. Yeah,
Okay.
exactly. Yeah. So I think you hit on both of the different ways to handle that, right? So make sure that you've already received a substantial amount of the money. And, it's hard to ask for that because you feel like you're asking them to trust you in a way, but you're not trusting them, but ask for it, right? Ask for it.
Yeah.
I want, I need this much money before I'm even going to give you that deliverable. And then the stick that you can use for that is, let's say that, they want to own the copyright, right? So they want to own all the intellectual property rights in the deliverable. Okay, when they get you, I will deliver this file to you, but you don't get the copyright to it until you pay to me in full. Right. So now I've delivered it to you, but if you use it and don't pay me, you're committing copyright infringement. Right. So that can also be that can be a useful stick to use, and, especially if they're expecting to be acquired at some point, they're going to need to show the person who's buying them that they own the rights to all this important stuff. And if they can't show that they actually own the copyright to whatever it is you delivered them, then that's going to affect them. And then they'll come back to you 5 years later and say, hey, we really need you to, sign this agreement saying that you transferred the copyright. And you say, well, that's great. I have this invoice here from 3 years ago. Maybe you'd like to pay that with interest now.
There you go.
Yeah. So, give yourself some leverage so that people can't cheat you, basically, is what I'm saying.
Yeah. Well, this is hard lesson learned the
Yeah,
hard way.
and
but,
there's only
this
one way to,
workshop couldn't be more timely.
Yeah, and I'll tell you.
Can I ask another question?
Yeah, sure. Well, let me one of the reasons I have, I do all my trademark work on a flat fee basis. And there's a lot of reasons I do that. Most of them are client-based, but one of them is me-based, right? So not only is it flat fee, they pay me first before I do I get the whole fee. Some of it has to go into a holding account because I'm not allowed to take a fee as a lawyer that I haven't earned yet, but I get it all up front. And when I started to figure out how much that fee should be, I was the highest collecting attorney in the firm that I was in, and I was still only collecting 85% of what was being billed. So at this point, I'm 100% because it comes in first, right? So to the extent that you can get the money up front, do it.
Yeah.
Unless if you have a client and you've been working with them for 10 years and they always pay
that's
you.
A different. Yeah, that's totally different.
Yeah.
But and what you said about copyright just triggered something else. And I have always put this final disclaimer that the intellectual property of the comps and design files are mine.
Are yours. Yep.
Always and forever.
Yep.
And so, but I've never copyrighted my graphic design. And so when I do a book, the content is copyrighted by the author. And there's a copyright in the author's name. I've never copyrighted my part of it.
Okay, well, here's the thing. So first of all, you have a copyright, whether you register the copyright or not. The copyright exists just poof, right? As soon as you sit down and write the paragraph, poof, you own the copyright. Right. You have to register it. Registering obviously gets you a lot of advantages like statutory damages for infringement, right? So, but it's not necessary. And you can't sue anybody based on copyright infringement until you've actually registered it. So if you are in a position where, for example, you think there's going to be a problem, you think they're going to use all of the, you presented them with 5 logos, let's say, and they only get the copyright to the one that they pick, right?
Mhm.
And you think they're going to steal from you, that would be a good moment to register that, right?
To register all 5 versions.
Yeah, right.
Or-
And
yeah, okay.
the good news is that's something you can do yourself at copyright.gov, and it's 30, what is it now? 35. They keep changing the price, but it's a pretty low price, right? So if you think that's going to happen, that would be
Mhm.
the thing to register. Yep.
That's great. Thank you so much.
Yep. You're welcome.
Libby?
Illuminating.
Yeah, hi, thank you for this, Michelle. My question is if I were to work on my own client agreement, kind of based off a template online, rewrite it in my voice, get it all how I want it to be, as a lawyer, would you say I'm okay to then just use it, or would you recommend showing it to a lawyer before I?
So as a lawyer, I can tell you, and you probably experienced this as well, so you'll believe me when I say it. It's like, if somebody says to me, well, I put this together myself, I want you to review it, how much is that going to cost? The answer is more than if you just let me do it again from scratch, right? It's always easier for me to create an agreement from scratch than it is to fix the thing that you've already created. Just like in the same way that if I drew a logo, you would look at it and weep. So yeah, so it's, if you, the key thing is to use common sense, right? Does it say what's supposed to happen? Does it deal with the contingencies, right? Does it take care of the things that I had listed in the talk, right? And if it's doing that, you're probably going to be all right. If you want a lawyer to do it, I mean, it's not going to cost that much. So if it's something you're going to use, 50 times every year, it's worth just paying a lawyer $1,000 to draft it for you.
Yeah.
Rather than, but if you feel comfortable, then go for it, right? It's not so much the legalese. I mean, the most important part of the legalese are things from your point of view as the person doing the delivering, is who owns the copyright, and just being really super clear about that. The rest of most of the other legal stuff is for their benefit. So don't sweat it too much.
And then as far as like making it in your company's voice, you're saying that you do that as well based on.
Yes, I do. Yeah. I write. I mean, I read your website. I read the stuff that you've already written, your blogs, like things like that, so that I can, as much as possible, sound in the same way. And then I tell my clients, if I haven't hit that, suggest changes so that it sounds more like you. I mean, ideally, my written agreements would include the F-bomb because that is my voice. But I probably don't go that far.
Cool. Thank you.
Mhm.
Lisa?
Thanks for the presentation. So being a former paralegal, it's the worst, but it feels like every time I send an agreement, I'm like, wow, I didn't think that could happen. So how do you know which legal bits to put in and put out? And it's like, it seems like my agreement was short and sweet, and over time it's gotten less sweet and more salty.
Yeah.
And
Yeah. And adds, something happened once, so now let's put in a paragraph about that. And this thing happened once, so let's put in a paragraph about that. And that can be really hard. But so it's really, again, it's common sense. Like that thing that happened, is that kind of weird? Like, who in the world would ever think that? Let's not put that into every agreement and make them 8 pages long, right? Or is it, the conversation that we just had with, where did she go? There, with Julia. I think it was Julia who asked about it. It's like that thing that happens over and over, right? The things that happen over and over are, they didn't pay you. They think they think everything's a deliverable, even though, you just like gave them 5 choices, right? The things that come up over and over again, those are the things that should be in your standard agreement. And the other things you might, we all get gut feelings, right? When you give them the proposal, you have a meeting, you're starting to talk to them, when somebody's the person who's gonna screw you, right? So then you get more robust, then you get saltier, then you get a little nastier in your agreement, you cover more bases, right? But, and is it always gonna be perfect? Is everything always gonna work out? No, but, go try to get, 90% of the time.
Right.
Yeah.
I think it works better in a weird sort of way. The agreements work better when it's closer to a peer-to-peer sort of relationship rather than like when I'm coming to them as an independent contractor and they're an agency, I feel like I'm at a supreme disadvantage.
Yes.
So
Yes.
that's when I'm always trying to cover my bases because they do things I was never expecting. Like when I work with like a business owner and I'm going to do their content strategy and they're a small business owner and I'm a small business owner, I feel like we're like, okay.
Yeah.
But, when you work with an agency, either they give you an agreement that you're like, what? Or you give them an agreement and they're like, great. And the next thing you know, everything they ask you to do, you're like, wait, that's not in the agreement. Wait, that's not in the agreement.
Right. Yeah. And again, that's where you can like put in like, like if it's listed in this thing that are add-ons, you really should have seen that, right? Because it's like, it's not like I was hiding the ball. I told you that if you want to add this on, this is how much it's going to cost. So what in the world could possibly have made you think that was included? Right. And if you're working with somebody who's not going to pay, you think they're not going to pay you in a timely way, throw that interest clause in there, right? Make sure you get to stop work, make it hurt them for not paying you on time, but if it's somebody who routinely pays you within 2 days of sending an invoice, you probably don't need that.
Right. Awesome. Well, thank you again. I appreciate it.
We have someone in the Creatives Roundtable who was working on a project and then the client disappeared for, I don't know how many months. And then person is in this room. You want to talk about it, Jay?
Yeah. How many months did he disappear for? Maybe was it like 3 or 4 months? Or oh no. That I've actually had 2 situations. This person, the first one, the lady, I think she disappeared for almost a year. About a year. And then so she just showed back up. She was like, oh, okay, let's continue. I was like, no, that's not happening. So I asked Nancy and the other people in my group, what do I do? So so I had to come up with a fee, and I had a discussion with her, and she was like, oh, that's not fair. I was like, well, if you read the contract, you'll find out that I can just walk away right now and you can't come after me. So you need to pay this amount of money. And she agreed to it. So
that's good. That's really good. Exactly. Because that's exactly the kind of situation that you can find yourself in. And then wow, a year she just
So is the restart fee like a common thing to put in, like if you disappear on me and
because you have to ramp everything back up again. You are in the middle of the project. It's kind of all in your head. You're working on it every day. It's there. And then you have to pick it up again after a month or 2 or a year. You got to go. You got to, you might have to do the research again because everything's changed. Absolutely. So, put that in there. And, again, like, I will send you the draft. You have 3 days to get back to me, right? So that everything's super clear. Yep.
And then Kara put something in the chat where she had hired a person that I recommended, and which I feel terrible about, but she was great. And she did not, she had to pay her 100% up front and she didn't deliver. You want to take over, Kara?
Yeah, I was just putting this in response to you saying get the money up front, where I feel very hesitant to now ever pay someone 100% up front, because I did, and she did not deliver a single thing to me, and she disappeared on me. And I was able to get half my money back through the credit card company, and I was able to get some of the work off of Asana that she had posted.
Yeah.
But I was just sharing that as, if
Yeah, no,
someone
I'm not
did that
saying
again, I would say no.
I have a lot of leverage as an attorney to
Yeah.
get that up front, and the fees are it's like a fifth of what I would get if I were charging by the hour. So people look at it and it's like a bargain, so they send me the money.
Right.
But I don't think in most situations you're not going to get the money up front, right? But what you don't want to do is get it all at the end either, right?
Right.
Yeah. So you want to make sure that you're compensated as you go, that the profit is built into that as well, and that if they walk away from it, you're going to get something, right? And again, it's never going to be perfect. That's just, we're human beings, and things are always going to go sideways. You just want to cover yourself as best as possible, without being psycho. Yeah, that's yeah.
Yeah.
Yeah, see,
Yeah,
I
usually
would I would get disbarred if I did that, right? So
yeah, you're
yeah,
at a higher obligation than
yeah, exactly.
folks.
Yeah, they're gonna grieve me, and then I won't ever make any money again. So yeah.
Yeah.
Marty?
Most of the people I work with, I've been fortunate, just do what they say they're going to do, although there have been, some exceptions. But I just find this very helpful, because having a conversation, agreeing out loud am I echoing, or is somebody else?
We're not hearing any echo.
Oh, okay. I guess it's just my ghost. I just find it really helpful because it prompts a conversation.
Exactly.
And I've learned my lesson about getting something up front, and I've made worse mistakes. I've never married a client. So, I just find it very helpful in formally having a conversation.
Exactly.
Everyone-
And that's, yeah. And by writing it in English so they can actually understand it, that's what prompts the conversation, right? Because if they don't read it, you never have that conversation. And then you have a misunderstanding, and then, then everything goes south. So that's exactly right. You want to have those conversations ahead of time. Yep.
I find a lot of my time as an editor is helping people not sound like lawyers, no offense intended.
There's no, yeah, I agree. I don't know why do they write that way? Like,
they think it makes it more important, and they sound smarter. I mean, I get a whole lot of including but not limited to, and I'm going, dude, if it includes it, it means it includes it.
Yeah, I know. There's phrases like, as soon as you see them, you just know it's badly drafted. Yeah.
What about limited liability for yourself, to protect yourself? Like, I have this phrase that says, Russo Graphics is not liable for incidental consequences that damages that arise from Russo Graphics failure to perform the contracted work within the agreed upon time. A lawyer did write this, unless the circumstances are beyond our control, such as loss of power from a storm, because we have that happen often in Connecticut, or illness or death of a family member. I had someone when my mom died who was like, when are you going to get back to work? And I'm like, I'm sitting Shiva for a week. See you, dude. And so, what about something like that type of?
Yeah, there's nothing wrong. Having a limited liability clause can help. If I were on the other side of it, there are certain situations where I wouldn't want to let you limit your liability. So for example, if you have promised that that you are transferring the copyright to me as the deliverable, and it turns out you just copied something off the internet and sent it to me, so you don't have the copyright, or you used AI to create it, so nobody owns the copyright. that's not a situation where I'm willing to limit your liability because you know exactly what's going on. But yes, you can definitely say, you know, no matter what happens, you know, other than these certain circumstances, no matter what, my company is never going to be liable for more than this much money, right? And damages, like that's just it. But again, I wouldn't use the words that the lawyer used, right? Because nobody understood I understood what it said only because I already knew what it was going to say. But
Right.
nobody else here, like she was 5 words in and you were just going,
Yeah, I was too when I was reading it.
yeah, it's
Um,
terrible, right? Why? It doesn't have to be that way.
And mine also says that in no instance will Russo Graphics liability exceed the amount that you paid me,
Right,
which is good. But
right. But
I
again,
also-
see, I would want an exception there for copyright, right? So if you're transferring the copyright to me and you didn't have the copyright to transfer,
yeah,
I'm not limiting it to what you pay me for what I paid you for the contract. But you
And-
don't have to put that in, but if I were
In-
reviewing it,
so I'll get to you in 1 minute, Emilka, because in regards to the copyright, so I have a clause that talks about warranty of originality, and then
Mhm.
I'm basically saying that my designs are original
Yep.
photos and illustrations I use. I have consent for use,
Yep.
and it's all to the best of my knowledge. And I have the best of my knowledge in because, you know, I think I come up with some original design, but now I know that search engine that you showed me with through that in Creative Co. I come up with something and then someone's like, wow, that looks a lot like XYZ. So yeah.
Right, but see, here's the thing. So there are things that you can know and things that you can't know, right? You know if it infringes somebody's copyright, right? So in that instance, if you draw a logo and it ends up looking like somebody else's logo, I mean, it's not like a copy of somebody's logo, it's just vaguely looks like their logo. You have transferred the copyright. You can't know whether or not they can use it as a trademark. You can't
Okay.
make that promise because you can't know that. You
Yeah.
can't know if it's patentable, right? You can't know that, but you know darn well if you're transferring the copyright, because if you sat there and created it yourself, then yeah, then you own and can transfer the copyright. That's just how it goes, right? So it's the different types of intellectual property have different levels of knowledge that you can have about them.
Okay, thank you. Yamilka, do you want to?
I do. Hi, Michelle. This is great. Thank you so much. I'm loving this. I am curious. I work, I work with artists and now with AI and everything. I want to know how a company like mine can protect itself, right, from people claiming that it's their original work and meanwhile it's AI. What do you suggest? Where do you think the industry is going? Is there a clause or something that we as artists and copywriters and designers, small businesses should consider as we move into this new era?
Yes, absolutely. And I've actually gone back and revised my standard forms of agreement for like independent contractor kinds of stuff. And you just flat out say it, right? That they cannot use AI in order to create the deliverables, period. And highlight it, you don't have to highlight it, but, make it really clear that that's really important, put it in its own subparagraph so that they can see it and they know that that's there. Because yeah, if they've promised to transfer the copyright to you and they use AI, then they haven't transferred the copyright to you, but like, what are you going to do about it after the fact?
And what do you suggest? Thank you. And what do you suggest? So that would be for like a vendor or a contractor.
Like a
What about
sub,
client
yeah.
facing? What, how can
Yeah.
my
So,
clients
I mean,
that
you should
I don't
assure
know.
them. I mean, you probably already say that, under these circumstances, you actually are transferring the copyright to them. I mean, and that really is enough. But if you want them to know, like, that you're aware of this problem, you could also put that same thing in there, that you won't use AI for any part of the creativity of the project without their express written permission or something like that.
Thank you very much.
Yep.
Appreciate it.
Janine, is Janine here? I don't,
Yes.
oh, there you are. Why don't you say it? Like too many faces. Why don't you bring up what you wrote in the chat?
So this is in regards to copyright. I am
Mhm.
curious about your thoughts on AI in general. So us as artists, like Adobe software has come very close to replicating artwork. How do we protect ourselves?
Yeah, so there's two issues with AI, right? One of the issues is that whatever you create using AI is in the public domain immediately. The other issue is, AI draw me a picture in the style of name somebody who's still alive, right? That's the other issue. And I think, outside of people in your field, there's very few people who are even aware that that's an issue. So that first issue, right, that there's a couple of laws. The answer to the second one, it's in the public domain. We know that. There's case law, there's guidance from the Copyright Office, there's everything we could ever possibly want. It may change in the future, but right now we know the answer to that. That first question, though, is if you have AI and that AI, the training set includes copyrighted images that you have created, and then that is used then to produce something. We don't know the answer to that question yet. We don't have that answer. There are several lawsuits pending that are going to help us know that answer in the future. But right now, we don't know if it's a violation of copyright for people to use one of your images as part of the training set.
So just for clarification, so I understand you. So if I create artwork, say I create a graphic and I use it for something for a client, but it's my graphic and I created it for them. Can AI come along and reproduce it, or is it because I'm using the software that has included AI in it? There's a conflict there. Like
no, it's not. So if you're using, there's really two different types of AI, right? And what I'm talking about is generative AI, right? So if it's just, I draw a line and I use a computer program to make the line perfectly straight, right? I draw a circle and I use it to do that. I, use it to modify images. It's a tool that I am using as a professional to help me create. Then you own the copyright because it's just a tool, right? But if instead I sit there and I say, I would like a cinematic image of a woman with dark brown hair with bangs and a gray sweatshirt and a white undershirt sitting in front of a partway open door, and it creates that image for me, nobody owns that.
Yeah, and my question is specifically to the first one. If I create something and AI reproduces it it picks it up from the web and reproduces it. Do I have to copyright all my work, or is it automatically copyrighted once I?
Right, by the act of your creation, it is already copyrighted. It is already, a copyright springs into existence automatically. You need to register it in order to get statutory damages. You need to register it in order to bring a lawsuit at all. But it is there, it exists. You don't have to register a copyright in order for the copyright to exist.
Thank you very much, Michelle. This was chock full of information and really great. And
I'm glad you guys had questions. Thank you. That was like, oh my God, we already got through it. Okay.
Well, you were very succinct, but it was great. Yeah, maybe we'll have you back sometime to talk about copyright.
Yeah, and honestly, guys, and you'll be getting my contact information. If you have like just a quick question or something, don't try to find it on the internet, because God, there's such bad information out there. Please just shoot me an email or something. If you get to be a pest and I can't take it anymore and you're bugging me too much, I will flat out just tell you that. So just reach out if you have a question. I'm always happy to help and answer questions.
Great. Thanks everyone for attending. See you soon. Bye-bye.
Take care. Bye-bye.
Thanks, Michelle.